this item 1 second number 21 of 2022.
Transfer property of the specific to the Where is the agreement? Exhibit A. Exhibit B. Exhibit A is 1977 का पूर्ण किराएदार.
This is the agreement.
No,
This is kiraya naam.
हाँ किराया नाम.
Where is the agreement of sale?
This is exhibit D.
पढ़िए.
Not from last line, so correct, because rest is the description of the land and not quite legible everywhere.
Keyword first line में दिया.
आगे
कुल कीमत 1,05,000.
that is the second page first line. उसका
और
start
second page first line.
हाँ, that is
उल्टा
second
लगा हुआ.
हाँ उल्टा लगा हुआ उसमें. First वही important line is नीचे की.
हाँ.
मकान की कीमत वहीं से पढ़ना पड़ेगा. मकान की कीमत बाजार दर पर एवं अन्य बातों के मद्देनजर कुल कीमत 1,05,000 तय किया गया. As Prakshit बोला. मेरा इलाज चल रहा है. कोर्ट कचहरी जाने के लायक हो जाने पर 2-3 माह के अंदर शेष रकम 65,000 लेकर रजिस्ट्री कर देंगे. और अगर मुझे कुछ हो गया तो मेरी पत्नी रजिस्ट्री कर देगी, जिसे मैं अधिकृत करता हूँ. क्योंकि लड़का पागल है और कुतूहू बिल्कुल बात से बाहर है तथा वह खरपोश का केस कर मकान हड़पने तथा किसी दिगर को बिक्री कर दूसरे के साथ भागने का भी इरादा बनाई है. और अगर ऐसा कभी होता है तो नाजायज समझा जाएगा. खाना पूर्ति की संपत्ति मैंने आप भाड़ेदार के लेखेदारी के साथ इसलिए किया है कि ये एक गरीब परिवार के हैं और मेरे मकान में रहकर साड़ी का काम 1966-67 से कर रहे हैं तथा परिवार का भरण पोषण करते आ रहे हैं और मेरी सेवा एवं मेरी आर्थिक परिस्थिति बिगड़ने पर बहुत मदद किए हैं. इसलिए इन्हें बेचकर बेघर कर इनके परिवार को भूखों मरने की नौबत पैदा नहीं करना चाहते हैं. साथ ही जब वे उचित मूल्य जो दीगर मिलने को वही दर दे रहे हैं. इसलिए मैं एवं मेरे परिवार के उचित समझकर तथा बहुत दिनों से लेखाधारी का बहुत दिनों से जाकर करने का रोजगार करने के आधार पर इन्हें मकान लेने के लिए अधिकृत भी समझा गया. इसलिए यह संविदा बिक्री संविदा आज दिनांक 15/3/2003 को आवाहन के गवाहन के समक्ष दिया दिया जो जबरी जो एक आज से
लगभग लेखाधारी का दखल कब्जा
आज से बहैसियत मालिक लेखाधारी का दखल कब्जा पूरी संपत्ति पर होगा। उपरोक्त जमीन की बातों का कथित मजमून को गवाहन के समक्ष कथित कातिब के द्वारा गवाही। So this is exhibit D. Now, Ladyship, may I read the judgment? Ladyship, there is a concurrent finding by both the court below. Appellate court order is quite legible because it is typed 1, concurring the judgment of the original court, whatever, it would be more easy to go through the appellate order.
no contradictions are seen.
No contradictions. May I read the judgment? This civil appeal number 06/2018 filed on behalf of Muhammad Tushir Alam and Muhammad Mumtaz against Ram Vilas Bhagat under section 96 read with order 41 rule 1 CBC by being dissatisfied. Judgment and decree dated 21/12/2017 passed by learned subject first Godda entitled election suit number 1 of 2009 and pray that to admit the memo of appeal and thereafter hearing set aside the impugned judgment and decree for the ends of justice. The ground taken on behalf of the appellant is that the suit has been decided under general provisions of Bihar Building Lease Rent and Eviction Control Act 1982 as the plaint was filed under section 11C of the said act. Thereafter, be called for BBC Act as ground taken for default in payment of rent and personal necessity. Two procedure cannot be followed in one suit. There is general provision for default and special provision for personal necessity, and court will follow only one principle of procedure, and that in the general procedure. Hence, the appeal lies before your court. Further, in para 10, the plaintiff on 5/7/2010 filed petition to treat the case under section 14 of BBC Act, and rejoinder also filed, and after hearing the petition dated 8/7/2010 rejected on 12/7/2010 and sued tried under general provisions, so the appeal lies before the court as no special procedure under section 14(4) has been followed at all.
These are his submissions.
Yes.
Finding the on the determination.
The briefcase of respondent plaintiff,
Which
that is para 3, running page 19, internal page 6. The briefcase of that respondent plaintiff filed a title eviction suit.
wherever there is no dispute, you just skip and proceed, right?
Yes,
Like description of property, there is
yes,
no
that I
dispute. Then the suit
Sure.
property was purchased.
which is self-acquired property. From here only the dispute arises.
Yes.
Which is a self-acquired property of plaintiff respondent, which turned as suit property. The suit property was purchased by plaintiff by virtue of registered sale deed executed by the last owner. The detail of the registered deed prescribed in Schedule B at the foot of the print. The plaintiff came in possession after sale deed of property. The defendant was in need of premises for his business, so approached plaintiff on the eve of Durga Puja 2006 and offered.
Plaintiff purchased, the suit property was purchased by the plaintiff by way of registered deed.
Yes, yes.
They were the plaintiffs.
Yes, they are the plaintiff, we are the
Yes, yes. Okay.
So they are the
Deed का date नहीं लिखा हुआ है.
deed का date आगे आएगा.
9 March 2006.
Sorry,
9 March 2006.
9/3/2006. Carry on, please.
The plaintiff came in possession after sale deed, and ladyship, because language is bit difficult to understand here, थोड़ा grammatical mistakes are there,
इसलिए
थोड़ा
बहुत
समझना
वो
पड़ेगा.
कांटा की तरह चुभता है grammatical
And
mistake.
while
वो बीच
reading
में
also,
एकदम
while reading also we stop because whether I am reading correct or what has been written, that is an impediment. By
कोई बात नहीं. We ignore those errors.
The plaintiff came in possession after sale deed of the property. The defendant was in need of premises for his business, so approached plaintiff on eve of Durga Puja 2006 and offered for giving the premises on rent, which was accepted by plaintiff on 1/10/2006. This is an important date. And rent was fixed at rupees 300 per month orally. The defendant occupied the premises and relationship of landlord and tenant established, and defendant paid rupees 300 month to month in cash to the plaintiff. It is also agreed that premises will be vacated by the defendant on demand of the plaintiff. That in the month of June 2008, the plaintiff asked the defendant to vacate the premises as plaintiff responded was himself in need of the premises as the land in which the plaintiff was carrying his business of garment. The rent has been enhanced, so the plaintiff feels personal necessity to shift his business to his own premises, and the defendant appellant had premised that in August 2008 he will vacate the premises, but the defendant do not vacating the premises and stopped the rent from the month of August 2008 and evading payment of rent on one or the other pretext. So the plaintiff given a pleader notice to the defendant 21/1/2009. 1 month has passed, but the plaintiff lawyer received reply from the defendant and filed this eviction suit against the defendant for eviction of the premise Schedule A property and recovery of areas from August 2008 to February 2009. The suit has been valued 3,600 rupees and rent of 12 months and ad valorem court fee of rupees 950 is being paid. Further written in the plaint that cause of action arose on 1/10/2006 when defendant occupied the premises as tenant on 1/9/2008 when denied to vacate the premise and became default in payment of rent for which legal notice was given and prayed to relief that a decree for eviction against the defendant for suit premise be passed in favor of the plaintiff respondent, including the arrears of rent of rupees 2,100 with cost and any other reliefs for which the learned could fix the proper to the plaintiff. May I stop here for a moment, leadership? The important dates are in March 2006, ये लोग possession में आए with by virtue of the sale deed. In October 2006, it was given on rent to me, which was an oral agreement between the parties, 300 per month. And thereafter, in August 2008, they wanted me to vacate the premise. Thereafter, I defaulted. I did not pay the rent. So nowhere they say that I have been in 2003 when I stopped paying the rent and I became the owner as per my pleading. I am saying it is not their case that since 2003 I have not been paying the rent. It is their case that they inducted me as tenant in 2006 and in 2008 I defaulted paying, and on their personal ground in the need of the property they want the property to be evicted.
So default is from 2008.
August 2008, not from 2003 that I have pushed it. And they inducted me in 2006. There is no whisper as if I have been in occupation or in possession of the suit property, which is my case. Now, defendant number 1. There are 2 defendants. They both filed their separate WS litigation.
Why separate?
Both of them
Just
were
like that?
Like that. Both
But
of
they
them.
were on the same books.
Obviously. Defendant number.
They have little difference because suit for a specific performance which has been filed. Khurshid Alam is the actually person whom agreement.
Who's defendant number?
Khurshid Alam is the appellant number 1.
Defendant number 1.
One.
He has filed the suit for specific.
No, the agreement of 11/12/2003, it mentions name of Mumtaj.
Who's not a defendant?
No, he is defendant number 2.
So defendant number 2 has filed the suit for specific.
Should be. Actually, they are claiming, though they say that same is similar, everything is similar, but this is material difference also.
And not defendant number 1.
इसमें इनका नाम नहीं है, जो बिड्डी जो अभी पढ़ रहे थे, इसमें ताजिम प्रसाद शाह का नाम है और मुमताज अली सचन सर जो कि डिफेंडेंट नंबर 2.
Direct leadership from defendant number 1.
पहले ये पिटिशन सिर्फ खुर्शीद आलम के लिए ही फाइल हुई। बाद में जब ये इनका रिटर्न स्टेटमेंट आया तो इसमें अमेंडमेंट किया गया, अमेंडमेंट के बाद दूसरा नाम भी इसमें हम लोगों ने जोड़ा।
Defendant number 1 appeared and filed WS and availed the pleading of plaintiff on forthcoming ground, that is maintainability limitation, no valid cause of action. Para 1 of plaint is admitted by defendant. Para 2 is of the plaint is denied as the suit land is coming with possession since 1966-67, work of coloring and painting of clothes executed by land of Tarani Prashad Shah in favor of the defendant, and it is wrong to say that the suit property was purchased by the plaintiff by virtue of the registered deed executed by the last owner. In para 3 of the plaint is totally denied by the defendant and say that plaintiff never came in possession of the properties. The sale deed is false and forged, which was made by the plaintiff. The para 4 of the plaint is also denied by the defendant and submitted that never approached to the plaintiff on the eve of Durga Puja for the need of premises because the defendant and his brother already coming in possession since 1966-67 and never fixed the rent of the building orally, rupees 300 per month, and the plaintiff never said to vacate the premises because he already in possession after self-agreement deed executed by Tarini Prashad Shah dated 15/12/2003 on which Basudev Shah also signed. He further denied in the paragraph 5 of the paragraph 5 of the plaint, which is false and concocted, and never paid rent to the plaintiff. Defendant also denied para 6 of the plaint that plaintiff never asked to vacate the premises land and has need of carrying business of ready-made garment. The August 2008 is a concocted date to vacate the suit land. The agreement of self-executed by Basudev Shah written that if he died, his widow Musawwat Shanti Devi registered the sale deed in favor of defendant, and Musawwat Shanti Devi filed written statement in title suit number 17 of 06. This is that specific relief. This title.
Who is Shanti Devi?
Shanti Devi is wife of father of Tarini Shah.
She had expired by this
No,
time.
Shanti Devi is wife of Tarini Shah. She has not expired.
Did she depose?
No.
Her evidence is
As on date, she has expired, but
must have, but did she depose before the court?
it is their case that she sold the property to him. He should have that.
No, Exhibit F is your document.
No, she deposed in that court.
No, she deposed in that court a certified copy of written statement of Mohammed Shanti Devi in title suit number such and such
Yes,
has been
yes.
exhibited.
That has been exhibited.
But she has not been confronted with the title, with the statements made in the title suit.
No, not at all. Ladyship, the fact is, this is a title eviction suit. They brought it against me, claiming their title over a property. Now, neither did they produce their vendor, this Vasudev Shah, Shanti
There is a
Devi.
registered document.
It is a registered document. Nobody from that, the vendor of the property, they have never come and did it.
It's once there is no dispute that the property stood in their name. Whatever, they were maybe that there was some problem regarding the this genealogy, but
Leadership, that specific relief act, the case is against Shanti Devi. Any which ways, she will never come in my favor and depose in a case in which I am contesting, and she will never support me. Why will she support me?
she was with them.
She was with them.
She was contesting the suit.
In that case, she is contesting separately. They are not the party because they are not at all having the right title interest and specific performance act for which I was in contract having with them.
So, since you are having a contract with Shanti Devi,
Yes.
then under such circumstances, there is no occasion for a subsequent purchaser to become a party in that proceeding.
Yes.
Because a specific performance has to be
Between the
executed
one,
between-
yes. Just two of us, not them. So they are not the party. And here,
Let me just understand, yes.
and here, when I say that I had no, this sale deed itself is not in exist. That is have been the forged and fabricated sale deed have been used.
No, you see, there is a sale deed.
Yes.
They produce registered deed or original deed?
That is a registered,
A certified copy.
certified copy.
Certified.
Certified copy.
Do you say that the certified copy is forged and fabricated or the sale deed is forged and fabricated? There is a difference between the two.
Yes.
that the certified copy is failed. If the certified copy is not forged in that, then under such circumstances, some registry has taken place. Maybe that the person is participating, or they have wrongly declared their title or whatever. But some deed has
Some
been
deed-
executed with respect to the suit premises.
Yes. That sale deed, I say that it was totally. Fraudulently got registered. That we have taken.
So fraudulently, it got registered, but there was some fraud.
Some fraud.
Now, when there are concurrent findings in connection with the relationship of landlord and tenant, what is to be scrutinized now?
Now, the what has to be scrutinized? Ladyship, the fact that have been pleaded in the plaint, either it has to be taken in entirety or some part of it. If they are taking, they are not denying that I have been in possession since 67, 68.
Not denying means they are filed up.
No, the finding of the court. They say that I have been in continuous possession since 67, 69. And he was the subsequent owner of the suit property. So, which is the settled law, ladyship. There is a judgment of ladyship also that if there is previously there was a owner and then thereafter registered sale deed has been executed, and when there is no cloud over the registered sale deed, then I would still be a tenant to the subsequent purchaser. There is no denying to that. That is a settled law. Now, what is the denial, the bone of contention is? Ladyship, my specific pleading is, since 66, 67, I have been in possession over the land. 2003, there was an agreement of specific relief and of part agreement for the execution of the sale deed in future within 3 to 4 months of Tarini Shah, if he will be well and he will execute a sale deed. In case he will not be there, his wife will execute a
So
sale deed.
your specific cases that your relationship with the earlier owner
Yes.
severed
Yes.
by virtue of execution of the agreement
Yes.
of the year 2003.
Yes.
That is your specific case.
That is
because thereafter you did not pay rent to anybody.
Yes.
Right? So therefore, even if you were in possession of the property, maybe by part performance of the
Yes.
agreement or whatever, then under such circumstances, the tenancy having been severed with your ex-landlord, there has to be a fresh tenancy.
There has to be a question.
Merely because you continue in possession, they cannot say that the tenancy would continue.
Ladyship.
Now, in the meantime, nor you can say that the tenancy will continue because your possession was different from the possession of your landlord.
Yes.
Correct?
Yes.
So, therefore, they, even if it is said that you were in possession of the property right from 1967, but there is a tendency when they say that they approached you after purchase of the land and then you agreed to pay rent of rupees 300.
Now, their case, they never admit that I have been in possession.
Need not.
They
There are
say-
specific cases that they
I
have-
approached in 2000, during the Durga Puja 2006, I approached and a tenancy was opened, and they also say in their depositions further that I have never been in occupation of that land. So either it has to believe completely, ladyship. My question is, like
Let us take your best case.
my
Your best case is that a tenancy with your ex-landlord severed. It is not their case that you are continuing in possession of the property as a tenant and therefore by virtue of purchase of the property you become their tenant.
No.
That is not their case.
it is not there.
They have not made out a case to that.
No.
And your case is also that the tenancy severed.
Yes, the tenancy.
And in the meantime they became the owner of the property.
No, my contention is that never became the owner of the property, and if there is, even if with respect to the sale deed that I have, because minutely or with a touch and go, the title has to be seen when it has to be declared that there is a landlord and tenant relationship between the
So
contesting
you
parties.
can at best claim what? You can at best claim part performance of contract.
Yes, I can at best claim.
So therefore, his contention is that you cannot claim part performance of contract because your agreement is not a registered document.
Ladyship.
Because there is a bar You just have a look at
In this particular case, I cannot even ask for part performance.
You
This
can't.
is their case. They filed an eviction suit
You
against
see,
me.
therefore the court will see prima facie title.
Prima facie, it will see.
Right? Prima facie it will see.
Yes.
Your case is that by virtue of part performance of the agreement, you are in possession of the property,
Yes.
and therefore you are the owner of the property.
I
And,
say
and
yes.
therefore, if anybody is claiming to be the owner of the property, you will resist by saying that you are in occupation of the property by virtue of part performance of the contract.
My
Under
case
the
is-
provisions of Transfer of Property Act, read with the provisions of Registration Act, in order to claim that you are in possession by virtue of part performance and resist the title of any third party qua that property, then that particular document on the basis of which you claim part performance is required to be registered.
Ladyship, in a specific performance act, in a case registered under specific performance act, where I am relying upon a document that in that case the registered of the whether the document is registered or not. Correct me if I am wrong. That has to be seen. Ladyship, here.
No. In case of specific performance of contract, even if the agreement of sale is not registered, that can be taken care of.
And
But when it comes to part performance of contract and a person in possession of the property by virtue of part performance of contract, that particular agreement is compulsorily registered.
but at the
We are having so many cases that the agreement of sale is not registered. It is a simple agreement of sale. Parties are entering into agreement that yes, we will
we
do
will
something.
execute
We'll execute a registered sale deed, entire amount is paid. That document is not registered. In none of the cases there is a
never
registered document to that effect.
Yes.
In none of the cases, as long as we have seen and nobody has raised any objection also, and rightly so. Because agreement of sale need not be registered so far as specific performance of contract is concerned. But when it comes to relying upon a plea of part performance of contract and to protect your possession of the property qua any other party who claims, that particular agreement is compulsorily registered. Is that the position in law?
Yes.
This is the position in law. So therefore, if you say that you are in possession of the property by virtue of part performance, ex facie, prima facie, on the face of it, on the face of the statute, if the document is unregistered, you cannot take such action.
Ladyship, in an eviction suit, the prima facie that has to be seen that there has to be an existence of a landlord and tenant relationship. Now, this is a agreement, oral agreement, as admitted by both the parties that it is an oral agreement. In the plaint of the plaintiff, nowhere it has been mentioned that somebody was present in whose presence this oral agreement was executed. Now, PW3, on whose deposition this case has been relied upon, he says he was
just
present.
listen to another scenario. If you claim for part performance under 53A goes, what is your status? Your status is still a tenant under the erstwhile owner.
Yes.
Correct? So therefore, if plea of part performance goes and if that particular document cannot be taken into consideration for the purposes of your claim of part performance, then the landlord-tenant relationship with the earlier owner continues till you get to tackle over the property. And the earlier owner has not been examined on behalf of either parties.
No, they will never come in my favor. They never brought.
Whatever they have done,
They
in
will,
order to defend.
and they never brought anybody, even of the sale deed. Only the advocate of that particular sale deed, he has come and deposed. Neither any of the persons nor the witnesses, nobody. Only oral evidences are there, and over oral evidences, what they say, ladyship. I am just placing the case. कि हम फलना है 2011 this deposition took place. What the oral evidence came forward with, in 2006 when I was purchasing chappal, I saw that he and the date specific with the specific date कि 2006 के इतना तारीख को 300 रुपया दिया जब हम चप्पल खरीद रहे थे. My lord, on the face of it, these kind of depositions that have been relied upon by the court below, and both the judgments have come against me. PW2 says that 3 says that I was present when this verbal tenancy thing happened. But that is no whisper of presence of PW3 in the plaint. PW5 further says कि हम वहीं पर थे इतना तारीख को in 2006 he deposed in 2011 and says कि मेरे सामने पैसा दिया गया. Ladyship, these kind of depositions which is on face of it, which shows the collusion, nothing beyond that, and no document showing that there was any verbal agreement between me and my landlord, what if they claim to be the landlord. When this landlord-tenant relationship at least which is not existing, there is no evidence with respect to any payment of rent, there is no evidence with respect, at best they could have filed a suit, encroachment tha. This eviction suit under Public Premises Landlord and Eviction Act, that is not sustainable when landlord and tenant relationship is not established. The deposition itself and my depositions, my evidences, I have brought on record the electricity bill of that particular time, Tarini Shah ka agreement, uski wife ka which says in the specific relief act, in her WS, she has specifically stated that the vendor of the plaintiff, he was of unsound mind. Now, as far as this sale deed is concerned, whether any case was filed for the cancellation of the sale deed or not, at that point of time, in 2006, for the first time this came to my knowledge, and this is their suit, they should prove. And when this title and that comes under cloud, and this tenancy is not admitted, and that has, and the PW's depositions, which I am placing before ladyship, that shows that there was no tenancy in between both the parties. सिर्फ इस पे कि इतना था 2006 में हम 21/10 सम सच एंड सच 2006 I was purchasing चप्पल from that shop और 300 रुपया दिया गया, that has been relied upon. On the face of it, the case is not sustainable, ladyship. The evidence that they have led, otherwise तो केस का जरूरत ही नहीं था. The moment this registered sale deed was produced, the moment they said that there is a tenancy, why then depositions and placing of other documents before the court below? Straight away, just looking into the sale deed, I would have asked to evict the premise. I never said that there is a sale deed in my favor. But I say this sale deed is not in existence. This is wrongly, it has been registered by playing fraud. I say that there is no tenancy between both the parties. Their depositions, their evidences may kindly be seen. And nowhere they have denied and cross-examined me that their vendor was not mad. Ladyship, may I place some, this is the case, ladyship. May I place the judgments?
Yes.
Ladyship, this is the judgment of Patna High Court, ladyship. Issue of title is raised, rent controller cannot decide. Para 63, 68, 69 and 71 would be relevant.
And you did?
63 I am reading. In this case, it may be noticed that the plaintiff's has In this case, it may be noticed that the plaintiff's case had been that it is he who inducted the defendant's predecessor in the interest as a tenant, whereas the case of the defendant is that despite execution of the deed of sale by their predecessor, Tip Narayan Singh to
Can you
Lakshman
read
Ram.
it slowly? And once again.
Yes. 63. In this case, it may be noticed that the plaintiff's case had been that it is he who inducted the defendant's predecessor in interest as a tenant, whereas the case of the defendant is that despite execution of the deed of sale by their predecessor, Tip Narayan Singh to Lakshman Ram by reason of purported deed of sale dated 4/12/1968, they continued to possess the suit premises in their own right. They Ram, by reason of purported seal date such as dated 412, they continue to possess the suit premise in their own right. The issue, therefore, which arises for consideration was as to whether the defendants came in possession of the suit premises upon their induction as tenants by the plaintiff when he purchased the land in question inter alia by reason of deeds of sale dated 3/9/1975 executed by Lakshman Ram in his favor, as also by reason of two other deeds of sale from co-sharers of T. Narayan Singh as mentioned herein before, or the defendant had been continuing in possession without any interruption whatsoever. The learned court below did not address himself to this vital aspect of the matter at all. Same is the case here as well, Divisha. Now, coming to para 68, 69 and 71. 68. In Budhumal versus Mahavir Prasad reported in AIR 1988 Supreme Court 1772, the Supreme Court held, it is true that section 23 does not make it obligatory on the court of small causes to invariably return the plaint once the question of title is raised by the tenant. It is also true that in a suit instituted by the landlord against his tenant on the basis of the contract of tenancy, a question of title could also incidentally be gone into, and that any finding recorded by a judge small causes in this behalf could not be res judicata in a suit based on title. It cannot, however, be gainsaid that in acting section 23 of section 23, the legislature must have had in contemplation some cases in which the discretion to return the plaint ought to be exercised in order to do complete justice between the parties. On the facts of the instant case, we feel that these are such cases in which, in order to do complete justice between the parties, the plaints ought to have returned for presentation to a court having jurisdiction to determine the title. Now, 69. The Supreme Court, in the fact of that case, also held that in the event it may not be possible to treat the suits filed by the original owner against the tenants to be suits between landlord and tenant, simpliciter based on the contract of tenancy in which an issue of title was incidentally raised. Now 71. Interpreting the aforementioned provisions, the Supreme Court held, we think that this contention is well founded. There are clear indications in the Act and rules that the rent controller does not have the jurisdiction to decide the question of title in the proceeding under the Act, whether it to be for fixation of fair rent or eviction. Tenant may raise several objections. He may inter alia take up the point that the opposite party is not the landlord. The definition of landlord under the Act is very wide and encompasses not only the owner but also persons receiving or entitled to receive the rent of building which has been let out or would be entitled to receive the rent of the building if it were let out to a tenant in one of the several capacities. Denial of title of the landlord is itself one of the grounds on which the eviction can be sought. Section 10 to 7. Sri Krishnamurti Iyer is therefore certainly right in contending that the Act requires the rent controller to consider this issue among others while disposing the application before him. But we think Sri Prasannan is right in saying that since the rent controller has no jurisdiction to entertain an application except by the landlord or a tenant, the question of title of the property is one of which his very jurisdiction depends. It cannot be described as a matter that is squarely and directly in issue in these proceedings to which any finality can be attached, as the rent controller, by deciding the issue wrongly, cannot cloak himself with jurisdiction where none exists. All that the rent controller has to do is satisfy himself that the person seeking eviction or fixation of fair rent is a landlord who has prima facie the right to receive the rent of the property in question. That the rent controller's jurisdiction on the issue is limited is clear from the proviso of section 10(1) of the Act. In order to decide whether the denial of the landlord's title is bona fide, the rent collector may have to go into the tenant's contentions on the issues, but he is not to decide the question finally. He has only to see whether the tenant's denial to the landlord's title is bona fide in the circumstances of the case. Ladyship, again I am going back to para 63, the last. I am placing that when there was a when there was the right title and interest was under the cloud, the plain ought to have been returned for presentation to a court having jurisdiction to determine. And the court's view that whether I was in the possession of the land since before, that has to be decided and seen by the court. Even that is there. Now, this is 2002-1 SEC 19 edition. Para 2 is the fact. In brief, I am saying the plaintiff herein filed the got the title by virtue of 3 sale deeds executed by the vendor of the land. The defendant says that defendant is in the suit premises since last 33 years and defendant executed the agreement for sale.
In what capacity was the defendant in the premises?
Yes. Defendant executed an agreement for sale.
Defendant was in possession of the suit property. In what capacity? As a trespasser, as a tenant? What was his capacity?
His capacity that there was an agreement of sale between the parties and he was residing in that property.
But never as a tenant.
The defendant contested
You read
the suit
para.
denying. Yes, I'm
You
reading.
read that.
Para 2 is the fact. The parties are referred to say as they are arrayed in the trial court. The respondent plaintiff filed title suit number 167 of 1982 such and such for eviction of the appellant defendant from holding such and such in ward number having an area such and such in good faith retire. The plaintiff averred that they purchased the suit premises under 3 registered sale deed of 81, 81 and 81 from one Kedarnath Sinha and immediately thereafter let them out to the defendant on monthly rent of rupees 300. Same is the case here. The defendant did not pay the rent from the date of the commencement of the tenancy. The plaintiffs have 6 sons, 3 of them
This is
are
irrelevant.
major. The plaintiff, yes. Now come to last but 4 line, the defendant contest. The defendant contested the suit, denying that he took the suit premises on rent from the plaintiff. He stated that he had taken the suit premises on rent from said Kedarnath Sinha about 33 years back. He, however, alleged that he entered into an agreement for purchase of the suit premises and an agreement for sale was executed by said Kedarnath Sinha in his favor on 14/9/1980 and from that day he has been in possession as owner of the suit premises. The defendant also filed title suit number 232 of 1983 in the court of such
Identical facts
Identical.
except the date of agreement. The crucial date is after 2001.
हालांकि ladyship इसमें 53A and the Transfer of Property Act 53A has not been considered.
Need not be, but that is the plea that you are in possession of the property by virtue of an agreement of sale. When a person is in possession of the property by virtue of an agreement of sale, his right is defendable only under section 53A. There is
And
no
he
other
was-
provision.
He was inducted as a tenant.
Earlier also, yes.
Yes.
But here also he says that he was in possession of the property by virtue of an agreement of sale, though he was inducted by the earlier seller, and in the meantime, that person who had put them in possession by virtue of an agreement of sale had sold the property to a third party, and the third party claimed that I have inducted you as a tenant.
Yes.
Identical facts.
Yes.
The only difference is that here is an agreement when it did not require a registration. Now you have an agreement which is compulsorily registered. So your entire plea is based on an agreement which is compulsorily registrable. So how do we look at it? In order to give even a prima facie finding that you are the owner of the property. Your suit for specific performance, for that the agreement need not be registered. That will take its own course, we do not know. But so far as your plea that you are the owner of the property by virtue of agreement of sale and therefore 53A. How does it? So, in order to give even a prima facie finding with respect to title of the property, which the court certainly has the jurisdiction, your entire reliance is on that agreement. How do you justify?
My entire reliance is on agreement, as well as that the plea of the plaintiffs in the plaint is prima facie based on wrong facts. And when they did not approach this honorable court with clean hands and with some
Those
concocted
are not
facts,
the points of law involved. Those are not the points of law involved. Here it's a substantial question of law. Read की तरह नहीं चल सकता.
I am reading just the points that have come in this case.
Okay, kindly read further. What is the finding of the court?
Para 14 onwards will be relevant, ladyship. इसमें ladyship, both the court below, the original court and the first appellate court came to a finding that there is no landlord-tenant relationship in existence. Second appeal was preferred. Preferred by the plaintiff. In that, it was held that the issue of title has to be looked into by the first appellate court, and it was remanded to the first appellate court. Then the defendant came before the Honorable Supreme Court. Honorable Supreme Court came into a finding that the title cannot be looked into. At best, a separate suit can be filed for determination of right, title and interest of the parties, but did not interfere with that finding of both the courts that there is no relationship of a tenant and a landlord between the parties. Now, para 14, where the relief prayed for the suit is of a larger relief, and if no case is made out for granting the same, but the facts as established justify granting of a smaller relief, Order 7 Rule 7 permits granting of such a relief to the parties. However, under the said provision, a relief larger than the one claimed by the plaintiff in the suit cannot be granted. These are cases where the courts which tried the suits were ordinary civil court having jurisdiction to grant alternative relief and pass decree under Order 7 Rule 7. A court of rent controller have limited jurisdiction to try suit on the ground specified in the special act. Obviously, does not have jurisdiction to the ordinary civil court, and therefore cannot pass a decree for eviction of the defendant on a ground other than the one specified in the act. If, however, the alternative relief is permissible within the ambit of the act, the position would be different. Next para, in this case, the reason for denial of the relief to the plaintiff by the trial court and the appellate court is that the very foundation of the suit, namely the plaintiff are the landlords and the defendant is the tenant, has been concurrently found to be not established. In any event, inquiry into title of the plaintiffs is beyond the scope of the court exercising jurisdiction under the Act. That being the position, the impugned order of the High Court remanding the case to the First Appellate Court for recording finding on the question of title of the parties is unwarranted and unsustainable. Further, as pointed out above, in such cases the provisions of Order 7, Rule 7 are not attracted. For these reasons, the aforementioned case are no assistance to the court heard in remanding. Para 17, however, we make it clear that this judgment does not preclude the plaintiffs from filing a suit for declaration of title and for recovery of the possession of the suit premises against the defendant. In such a suit filed within, if such suit is filed within 3 months from today, we direct the same shall be filed.
You see, the finding of landlord-tenant relationship is staring at you. Concurrent finding. There is no scope for the appreciation of this. Merely because one witness has been believed by both the courts, and merely because there could be a reason not to believe that witness, is not a ground for interference, and that does not make appreciation of evidence perverse. Perversity is much more than both the courts have relied upon those evidences. Further, no question of law has been framed in connection with appreciation of evidence. we will not go into the fact of concurrent findings with regard to after appreciation of evidence with regard to the relationship of landlord and tenant. There is no scope. The law debars me from doing that. Even the law says that a question of law is not enough to interfere in second opinion. It has to be a substantial question of law. And the substantial question of law, as designed and stated by the Honorable Supreme Court, is essentially a pure question of law, which either has not been decided by the concerned High Court or by the Honorable Supreme Court. If we see it from this parameter, 99% of the second appeals are fit to be dismissed. But still we know that there is error in appreciation of evidence. There are perversities and the hard realities of our state. At times the persons are aggrieved, the manner in which, even in case of concurrent findings, we are framing question of law on the point of perversity. But it has to be expressed. It just can't be on reappreciation of evidence. 3 witness आया, 2006 का घटना था, 2011 में बोला, therefore they should have been disbelieved. ये कोई reason नहीं है. Everybody has their own memory. We do not know. I might forget anything after 5 minutes. You might not even forget after 20 years. We do not know. So ये कोई reason नहीं है उन witnesses को disbelieve करने के. और second appeal में एक concurrent finding को disturb करने के. That will make my judgment perverse. So वो scope नहीं.
Mention one that important unregistered sale deed is admissible piece of evidence. Para 12 and 16. 2010-5 SCC.
अभी तो आया है, इतना पुराना में आप कहाँ चल रहे हैं? अभी नया जजमेंट आया है.
वो वाला ढूंढे सुबह भी कर
नहीं मिला.
वो नहीं मिला because it was
सोचा आप खोज लेंगे इसलिए आप नहीं ढूंढे.
It was haunting me since yesterday, which judgment leadership was talking about, and I was searching.
गोराई जी को बुलाइए, गोराई जी को बुलाइए.
Para 12 leadership.
This is first a fact. Without the facts, there is nothing. This was a fact for specific performance of contract.
This is a fact. Yes, specific.
No, we don't have any issue on that. When it comes to 53A,
इसका सिर्फ एक पैराग्राफ इसमें स्पेसिफिकली बताइए.
बताइए कौन सा पैराग्राफ? ट्रांसफर प्रॉपर्टी का
16 में.
Yes.
The issue before us is only with regard to the admissibility of the unregistered sale deed dated 27/2006 in evidence, and therefore it is neither appropriate nor necessary for us to consider the contention raised by the learned counsel for the respondent about the maintainability of the suit as framed by the plaintiff or the circumstances in which the sale deed was executed. If any issue in that regard has been struck by the trial court, obviously such issue would be decided in accordance with law. Suffice, however, to say that looking to the nature of the suit, which happens to be a suit for sale, that not this. Para 12 amending. The main provision in section 49 provides that any document which is required to be registered, if not registered,
Sorry, para number 12. Yes. Yes.
The main provision in section 49 provides that any document,
Just a moment.
section 49
Alright.
legislation,
एक एग्रीमेंट ऑफ सेल फॉर इमूवेबल प्रॉपर्टी पर एक आया है जजमेंट जो अपने घर से 6 महीना पूरा थोड़ा सा ज़्यादा रिगार्डिंग वेदर इट इज कंपल्सरीली रजिस्टर्ड और नॉट. ये जो एग्रीमेंट ऑफ सेल है व्हेन इट कम्स टू पार्ट परफॉर्मेंस 53A एंड व्हेन इट कम्स टू स्पेसिफिक परफॉर्मेंस ऑफ दोनों में requirement whether it is compulsorily registrable is slightly different. इस पर judgment आया है सुप्रीम कोर्ट का, थोड़ा देखिए तो मिलता है.
Paragraph. The main provision in section 49 provides that any document which is required to be registered,
सूरज lamps consider किया.
that any document which is required to be registered, if not registered, shall not affect any immovable property comprised therein, nor such document shall be received as evidence of any transaction affecting such property. The proviso, however, would show that an unregistered document affecting immovable property and required by the 1908 Act of Transfer of Property Act 1982 to be registered may be received as an evidence to the contract in a suit for specific performance or as evidence of any collateral transactions not required to be affected by the registered instrument. By virtue of the proviso, therefore, an unregistered sale deed of an immovable property of value of ₹100 and more could be admitted in evidence as evidence of a contract in a suit of specific performance of the contract. Such an unregistered sale deed can also be admitted in evidence as an evidence of any collateral transactions not required to be effected by registered document. When an unregistered sale deed is tendered in evidence not as evidence of a complete sale but as a proof of an oral agreement of sale, the deed can be received in evidence making an endorsement that it is received only as evidence of an oral agreement of sale under the proviso of section 49 of 1980. So not only specific relief act, in other cases also where the reliance is made upon the sale agreement and which is not registered but it is an admissible piece of evidence, it cannot be brushed aside just because it is not an admissible piece of evidence.
The term in 53A, the contract though required to be registered has not been registered or has been omitted.
Yes, that has been
The purpose that has been omitted, and therefore, in order to claim title by virtue of past part performance of it, difficult to rely upon this document. क्या बोलना है आपको आगे? आप भी नहीं लाए जजमेंट? लाए?
First, I would like to see this shown the definition of sale. Let us see what is section 54. Sale defined. A sale is a transfer of ownership in exchange for a price paid or promise or part paid and part promise. Sale how? Such transfer in case of a tangible immovable property at a value of 100 rupees and upwards, or in case of a reversion or other tangible things can be made only by a registered instrument. In case of a tangible immovable property of a value less than 100 rupees, such transfer may be either by a registered instrument or by delivery of property. Delivery of tangible immovable property takes place when the seller places the buyer or such person as he directs in the possession of the property. Contract for sale. A contract for sale of immovable property is a contract that the sale of such property shall take place on such settled between the parties. Such terms settled between the parties. It does not of itself create any interest or charge on such property. Law ownership is very, very clear. Had it been a registered instrument, even for a moment, that had it been a registered instrument, by virtue of registered agreement, no right
Title
as such,
does not
no right
pass.
as such will be created.
Title does not pass.
then in case of part performance, it will make a
You
difference.
see, it is not your case that they were the tenant under your vendor.
No, it is not my
It
case.
is not your
my
case.
It is my case is that in the year 2006, that's 9th of March 2006, the property was purchased. This shop was constructed. They consulted us. It was given, and I asked him to vacate it. Thereafter, when they did not vacate, this suit was instituted, and accordingly, they have also brought their
And
evidence.
the suit is not on account of claiming title and eviction.
No, not at all.
Suit is on landlord-tenant
That is
relationship. 53A would come into play when you are seeking title and eviction.
Yes.
When it comes to landlord-tenant
Only
relationship,
to landlord.
only landlord-tenant relationship
Had
is
it
to
been
be
a
seen.
case of a suit for eviction,
Yes,
in
by
a
claiming
suit,
title.
title suit,
Title and eviction.
eviction, or for the recovery of possession, then in that case, 53A would come into play. Even for assumption that it has come into play or certain protections have been given to a tenant. But there are certain requirements here. First and foremost requirement as per section 17, Your Lordship may kindly see registration.
Registration.
Section 17, Your Lordship. I would like to place the reliance, Your Lordship, on 1A.
Yes.
The documents containing contract to transfer for a consideration or any movable property for the purpose of section 53 of Transfer of Property Act 1882 shall be registered if they have been executed on or after the commencement of registration and other related laws, Amendment Act 2001, and if such documents are not registered on or after such commencement, then they shall have no effect for the purpose of section 53. Let us see, my lord, section 53. Purpose. When any person contracts to transfer for consideration of any movable property by writing signed by him or his behalf, from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty, and the transferee has in part performance of contract taken possession of the property or any part thereof, or the transferee being already in possession continues in possession in part performance of contract and has done some act in furtherance of the contract. That is relevant. And the transferee has performed or is willing to perform his part of the contract. Then, notwithstanding, my lord may see 46 which has been deleted.
Yes, that has been.
Yeah, that is.
Yes.
Contract through which the required to be registered had not been registered. Earlier, now it has been deleted. So, the necessary implication would be that if
You
the
read further that notwithstanding that,
notwithstanding
where there is an instrument of
when
transfer.
there is an instrument of transfer and that transfer has been completed, had not been completed in the manner prescribed therefore by the law for the time being in force, the transferor or any person claiming under him shall be debarred from enforcing against transferring, and the persons claiming under him any right in respect of the property of which the transferee has taken or continued in possession other than a right expressly provided by the terms of the grant. Provided. Nothing in this section shall affect the right of a transferee for a consideration who has no notice of contract on the part of public. My lord, my submission you must be the first and the foremost submission that my lord, the exhibit D, which is dated 15th December 2003, is an unregistered document. And my lord will find that my date, your lordship, is 9th of March 2006. And your lordship, this is a registered statute. And my lord, though they say that it is fraudulently created or something like that, but this still has not been, they have not challenged this. It has been unchallenged. My lord, I would like to rely on section 16 of the Registration Act. Your lordship may kindly have a look on section 16. When a document your lordship is registered, and my lord, as per the provisions contained in my lord, the Registration Act, then my lord, such documents has a presumption of correctness. Whenever it is produced in any court of law, then my lord, the presumption would be that they are my lord, the valid documents, unless and until my lord, if somebody my lord, contends that it is a false one or something like that, then the owner sits on them. The lordship may kindly see clause 2. Once a certificate is granted, such certificates are signed, sealed, and dated by the registering officer and shall be admissible for the purpose of proving that the document has been duly registered in the manner provided by this, and that facts stated in the endorsement referred to section 59 have occurred as mentioned here. So, my lord, this is a registered document, and my lord, they have not challenged this document. They have not challenged this document. It is still valid. And my lord, pursuant thereto, they contacted us, and it was let out to them. And my lord, when they default in payment of rent, and my lord, when I required it on personal necessity, then the suit was instituted and it has been agreed. And thereafter, my lord, the appellate court has also affirmed. So regarding the landlord-tenant relationship, as well as my lord, default and the personal necessity, there is a concurrent finding of fact. Then, my lord, one more thing I would like to point out. Though this document is not on record, but I have a copy of. But I have a copy of their plan. I have a copy of their.
No. We'll not look at anything which is not.
Yes, correct. Just to mention.
You don't need to. Don't mention it. That's all.
Leadership, I just want to read out the finding with respect to the issue, that with respect to the relationship landlord and tenant, and the fact that has come by both the books.
Just refer to the finding.
Yes, page 57.
First try.
Leadership, it will be more
Let us see the issues. Let us see the issues frame and we'll come.
Leadership, may kindly come to the suit, main suit, leadership.
Yes.
Handwritten.
Para number 5.
Yes, para 5. On the basis of pleadings of the plaintiff and defendant following issue, is the issue as framed maintainable? Has plaintiff valid cause of action for the suit? Whether plaintiff is absolute owner of the suit premises? Whether relationship of tenant and landlord exists? Whether plaintiff has bona fide requirement of the suit premise? Whether the partial eviction of the suit premise fulfill the demand and necessity of the plaintiff? Is the plaintiff entitled for relief as claimed? Now, ladyship, these are all the facts and the
We are
exhibits
concerned with issue number 1, 2, 3 and 4.
Yes.
Correct?
The finding would come running page 57 may kindly be seen, internal page 18.
57. Yes.
Ladyship, jitna registered and just everything has been mentioned, and thereafter what is the finding? Last का तीसरा line से DW1, DW2. Has Lordship got it?
DW1.
DW1, DW2 and DW6 depose that after sale agreement Exhibit D, defendant stopped payment of rent. It is apparent from evidence of the defendants that Tarini Shah, now this is the finding. Tarini Shah had terminated tenancy of defendants on the event of Exhibit D sale agreement. Rather, defendant have stopped payment of the rent and Tarini Shah died in year 2004. Further, Tarini Shah's son Vasudev Shah became owner of the suit premises on basis of sale agreement. Exhibit D.
Exhibit D is the agreement which you are relying on.
Yes.
This one. Exhibit D.
Exhibit
D है ना?
D. Defendant cannot be owner of the suit premises and land. Their status of tenant will remain as it is. Ladyship, it is never their case. Again and again, it is their case. In the year 2006, I was inducted as tenant by them, and there is no discussion as if that I have there.
It is one thing to say that the status of tenant as to who would be the landlord, but your status as a tenant does not change. Whosoever be the landlord, but your status of permissive possession by way of tenancy will not change.
Further, plaintiff on the basis of sale, Exhibit 1, executed by Vasudev Shah, become the owner of the premises and land as well as landlord oral tenancy agreement and payment of rent at the rate 300 per month by defendant to plaintiff established by evidences. Plaintiff has given legal notice to pleader and admitted in para 14 of WS of defendant number 1 after appreciation and of the evidences of both the parties. Oral for documentary, I hold that plaintiff is absolute owner of the suit premise and ownership relationship of landlord and tenant exists between the parties. So the finding itself that shows leadership that what I have mentioned in my WS, what is my pleading, that part of that pleading has been considered and part of their pleading, the plaint has been considered and they have arrived into the
First judgment, Your Lordship, I would like to highlight.
Just a moment. Just a moment. Yes, what about the appellate court? Let her finish. Appellate court, you wanted to show the findings.
same finding has been given. There is a
Paragraph number, where is the point of determination and the paragraph?
finding starts from para 11. Para 12 is issue 3 and 4. Therein, issue 3 is whether plaintiff is absolute owner of the suit premises, and issue 4 is whether whether relationship of tenant and landlord exists. These are the two main issues.
Where is it mentioned? 3 and 4, para 11.
Para 11 it starts, para
Yes.
12 from there. Then all the depositions have been explained, leadership, and para 20 finding of the court starts from perusal of defendant witnesses. That is running page number 50, internal page 17.
Yes. But here also thereafter discussion of evidences.
Yes, thereafter.
And then page number 32.
After perusal of the report.
Yes.
Court's observation, both claiming title. Internal page 19 edition. After perusal of record, it transpired that defendant claimed on the basis of sale agreement as owner of disputed shop, whereas plaintiff claimed as owner of claiming shop on the basis of registered sale, and he suit filed for realizing due rent and also vacate the shop for personal necessity of plaintiff, but plaintiff do not establish that he required the shop for personal necessity. He purchased the shop from Basudev, but Basudev do not came in the court to support for due rent of on defendant. After evaluation of oral and documentary evidence, it transpires that PW2 plaintiff has purchased suit premise through sale deed exhibit 1 on 9/3/2006 from Basudev Prasad Shah, son of Tarani Prasad Shah. Oral tenancy agreement of defendant with plaintiff approved on 1/10/2006. PW3 came and support in para 8 that he has seen Ram Vilas was taking rent from Mumtaz on 2/10/2006. PW4 also corroborated that payment of rent realization from Mumtaz of rupees 300 per month by Khurshid to Ram Vilas on 4/9/2007. PW5 also supported the payment of rent December 2007 to Ram Vilas by Khurshid. So in this way, PW3, PW4, PW5 have seen the payment of rent by defendant to plaintiff at present time, which established the relationship of owner and tenant with relating to the suit premises. The plaintiff has corroborated the pleading in this respect, and notice to defendant to vacate the house on 1/9/2008 is admitted in para 14 of WS by defendant number 1 DW1. Deposed that since 1966-67 his father Usman Ali was tenant of Tarani Shah. Suit premises was further taken on rent rupees 300 per month from Tarani Shah by rent. On date 15/12/2003, sale agreement exhibit D executed by Tarani Shah. After that, he stopped payment of rent. On the meantime, Tarani Shah died and denied by the defendant relation of renter and tenant with plaintiff. Defendant filed the suit number 17/2006 against Shanti Devi instead of his son, and DW2 proved his sale agreement, Exhibit A, and deposed that after sale agreement stopped payment of rent to Tarani Shah. DW4 has not seen any fact. He heard that Mumtaz is tenant since 40 years and he has no knowledge about the document relating to case. DW5 deposed that the dispute took place with Ram Vilas. He has not seen any document, so this witness is not found credible. DW6 defendant Khurshid deposed that Tarani Shah given suit premises on rent to his father Usman Ali, and after his death both defendant became tenant and Tarani Prasad. Of Tarani Prasad further proved exhibit AB rental payments. In para 27 he deposed that sale agreement exhibit D was not registered, which required registered according to Registration Act, and it will not confer any title to any person party to agreement. Basudev Shah, son of Tarani Prasad, is a lunatic person, but no any medical proof on the record that Basudev Shah is lunatic or weak mind person. The assertion of any person cannot be declared or presumed unsound in certain interval, whereas he can be fit to make signature on the sale agreement which filed by the defendant. Tarani Prasad died in the year 2004, so Tarani Shah's son succeed the shoe of Tarani Shah and become the owner of the premises on the basis of succession, and defendant cannot. Ladyship, again there is an objection. This very observation by the finding by the court. He was the son, but he had there were
You
daughters
see,
also.
as long as he is one of the successors,
Yes,
is sufficient.
he is one of the successors. At best, he could have given only his part of share to the defendant.
1/6 of 300
1/6.
of 300.
Yes. No, not that. The suit premises when it was given on
That is not
by virtue of sale deed. At best, his property could have been entrusted to him by virtue of sale deed.
The sale deed is not under challenge, madam. You cannot question the sale deed.
Tarani Shah's son succeeded the shoes of Tarani Shah and became the owner of the suit premises on the basis of succession, and defendant cannot be owner of the suit premises and land. The status of tenant will remain as it is, and he is liable to pay rent of premises which taken by rent. The agreement to pay rent of rupees 300 per month by the defendant remain continuance after taking the status of ownership is given legal notice through pleader which admitted in para 14 of
You would say that the notice was actually illegal. So it doesn't written this.
That is the intention that he had actually, but
He knew.
as he
You
knew
knew it reflected.
that reflected. But there was no consonance between what he was writing and what was there in his mind. The perusal of LCN and all oral and documentary evidence are produced on behalf of both sides. This appellate court found that the learned court rightly decided the issue number 3 and 4 in favor of plaintiff and against defendant. The appellate court do not found to intervene in finding of 2 points.
You just to share, this case was filed in 2022. Remained effective for quite some time. Ultimately, while we have last chance करके एक order हुआ, the issue was framed on 6/2/2025 and we are disposing of today. You should appreciate this. कहाँ होता है? इसीलिए जिस केस में हम क्वेश्चन ऑफ लॉ बनाए हैं,
वो होगा.
वो अगर आ गया रिकॉर्ड मेरे पास, तो हम डिसाइड करेंगे फॉर श्योर.
Ladyship once said that while framing the question
Yes,
of law,
yes.
that time itself
बहुत सारी चीजें क्लियर हो जाती हैं, लेकिन फिर भी
becomes apparent that
एक बार सोचने समझने की जरूरत है, और खास तौर पे ऐसे इश्यूज जो नॉर्मली सिविल कोर्ट्स के पास आ रहे होंगे, उसको डिसाइड करना ही चाहिए. एंड दे माइट बी इन अ स्टेट ऑफ फ्लक्स कि क्या करना है. इसलिए चलिए अब लिखिए. अभी तो ये लोग ऑर्डर्स के लिए वेट कर रहे. कितना ऑर्डर्स केसेस है? नहीं होगा, ज्यादा तो नहीं होगा.
इसमें कुछ गड़बड़ तो है।
हाँ, जजमेंट आप लीजिए. क्या अभी और जजमेंट बाकी है?
हाँ, हमने तो दिया ही, इसके बीच मैडम पास करने लगी.
जो ज्यादा परेशान है वो ज्यादा बहस करेगा. जब jurisdiction की बात होती है, one sentence is enough. The order is without jurisdiction. Defendant अपना बताते रहे कि कैसे jurisdiction. बताइए.
एक तो जजमेंट हम इसमें सुप्रीम कोर्ट का जजमेंट एग्रीमेंट से कोई राइट नहीं.
You have relied upon 3 judgments, I suppose. 3?
yes,
2002,
इसमें
2010
पारा जो है सो
and 1 1991.
पारा 15
मिला जजमेंट? कैसे आप लोग खुजते हैं? हम खोजे नहीं, हम सोचे आप लोग तो लेकर आइएगा. कहाँ नया जजमेंट लेके आए? लाए हैं? फिर आप उसको कहाँ रखे? ये 2023 लाई ये बात.
सुप्रीम कोर्ट का तो नहीं मिला, लेकिन दिल्ली हाई कोर्ट का और पंजाब हरियाणा हाई कोर्ट का हमने लाया.
देखते देखते.
कौन सा जजमेंट?
आप बताइए, आप क्या, आप पहले प्लेस कर लें.
मैंने इस पॉइंट पे लाया है कि
घनश्याम, ये घनश्याम वाला judgment. हाँ बताइए.
वो इसका पारा तो हमने
बताइए.
ये पारा 50. Legally, an agreement to sell may not have regarded as a transaction of sale or a document transferring property rights to individual property.
पहले पढ़िए, आराम से आराम से. Legally, an agreement of sale.
Agreement to sell may not be regarded as a transaction of sale or a document transferring the property rights in immovable property, but prospective purchaser having performed his part of contract and lawfully in possession acquired possessory title which is liable to be protected in view of 53 of transfer of property. Said property right is protected, purchaser cannot be invited by the transferor or any possession. On this part, I am relying that section 54 से कोई right नहीं होती है. Section 54 से itself it is true. कोर्ट ने कहा कि agreement to sale is neither a document of title nor a date of transfer of property by sale. Therefore, it does not confer any absolute title on the property. However, if the factors of an infinity agreement, say payment of entire consideration and being put in possession by transferor source, that the defect of possession right passed to part performance of sale, the possessory right is not liable to be disturbed by the transferor.
ये पैरा नंबर कौन सा पढ़ रहे? ये कौन सा judgment? यही वाला ना?
हाँ ये
पैरा नंबर कौन सा? 14.
पारा नहीं पता नहीं. माइलॉट ने भी इसे रेफर किया था कि इंटायर कंसिडरेशन के ऊपर जजमेंट आया.
ये है क्या entire
ये
consideration?
सब
अच्छा, हाँ बताइए तो चलिए हमको लग रहा था,
पर
no doubt.
No doubt, agreement to sale is not a document of trade, or a deed of transfer of property by a sale, or as such may not confer absolute title on the plaintiff responding to the suit liberty in view of section 54 of the Transport Act. Nonetheless, the agreement to sale the payment of entire consideration as mentioned in the agreement itself and corroborated by receipt of the payment and on fact that the plaintiff respondent was put in possession of the property in accordance with law. It is also established by possession memo on record was to prove that the plaintiff respondent is a de facto having possessory rights of the suit being part of. This possessory right of plaintiff respondent is not liable to be disturbed by transfer. The entry of defendant reliant on the part of the property simply licensee as a licensee of the plaintiff does not continue to occupy the estate. इसका केस में इन्होंने इनका कुछ भी एडमिशन है इंटायर कंसिडरेशन नॉट
Even if the entire consideration is,
जी
even if the entire
even if भी
consideration,
नहीं
then also licensee होगा, permissive possession होगा. The title will not be applied.
हाँ टाइटल नहीं होगा इनका केस में तो रजिस्टर्ड इन्वेस्टमेंट नहीं है 43 ए का भी 53 ए का पोजीशन नहीं है
देखिए हम बीवीसी एक्ट में है,
हाँ।
इतना फाइंडिंग नहीं रिकॉर्ड करते कि इनका सूट कहीं खराब हो जाए चाहे आपका प्रॉब्लम हो जाए. We do not know because एक specific performance of contract चल रही है. अब तो क्वेश्चन ऑफ लॉ तो आंसर करना पड़ेगा ना, अलाउ डिसमिस की कोई बात नहीं है.
हाँ बस
क्वेश्चन ऑफ लॉ आंसर करना होगा एंड चूंकि सब्सटेंशियल क्वेश्चन ऑफ लॉ है, बाकी कोई इसको साइट करे चाहे ना करे, बट द मोमेंट इट इज साइटेड and if the court takes a contrary view, they have no option but to refer it to a larger bench. And as long as the substantial question of law is decided in a second appeal, it is binding for the entire state. उसमें कोई doubt नहीं. This is one of the jurisdiction which actually adjudicates upon questions, substantial questions.
यस
इसीलिए बहुत ध्यान से इसको करने का है, ऐसा नहीं और सारे litigations को नजर में रख के करने का कि किस किस तरह के litigations हैं. ऐसा fact based नहीं कर सकते when it comes to answering a substantial question.
और 32 इस जजमेंट दिल्ली हाई कोर्ट का जजमेंट में इन्होंने कहा कि 2001 का एप्लीकेशन को कंसीडर किया. It is well settled that in order to give benefits of 53A of the Transport Act, documents relied upon must be registered. Any unregistered document cannot be let into by the court and cannot be relied upon or taken in evidence in view of the section 71(1)(a), which I was just reading, with read with section 49 of the Act. Thus, benefit of 53A could have been given to the respondent if and only alleged agreement to sale cum receipt satisfied the provisions of section 71 of the registration. एक जजमेंट में पंजाब हाई कोर्ट का एक जजमेंट भी है
इसी पर
इसी पॉइंट इसको इसका पैराग्राफ ये लास्ट पैराग्राफ काफी कुछ इन्होंने कंसीडर किया. इस पर के बाद ऑब्जर्व करें कि बेयर पेरिजन ऑफ एफोर्सेड प्रोविजन makes it manifestly clear that such an unregistered agreement by position is delivered shall have no effect for the purpose of section 53 of the Transport Property Act. In other words, such an unregistered agreement cannot be used to benefit of section 53 or prohibit user of such agreement for any other purpose of 53 of the Transport Act. Consequently,
it is because of this reason his specific performance of contract में बात है. It is only because of this reason. 53A में specific provision है, 17(1)(a) में specific provision है, इसीलिए part performance में it is required to be compulsorily registered. Otherwise it can be looked into for any other purpose, transaction of money or possession or whatever.
लेकिन क्वेश्चन ऑफ लॉ में
हाँ क्वेश्चन ऑफ लॉ में तो इसका आंसर करना है.
इसी के लिए रेफरेंस टू डाटा.
ठीक.
इसके अलावा इसमें एक चीज और भी हमने लास्ट एक कहा कि पोजीशन हैज बीन डिलीवर्ड टू अस. उसके
वो possession has been delivered.
बाय एक्सक्यूशन प्रोसीडिंग वो जजमेंट वो ऑर्डर हमने कल दिया.
हाँ, is it a fact?
but they are objecting to it and they have filed an application.
That's right.
that they have wrongfully been evicted from this.
और वैसे भी इसके लिए आपका केस थोड़ी डिसमिस और अलाउ होगा.
But I'm just explaining the current status of the
हमने कल ही इनको दिया था, इसमें हम पोजीशन में बाय वैलिड डिस्कशन प्रोसीडिंग आए, तो अब इसमें हम ये पोजीशन में नहीं है, हमें पोजीशन मिल गई है एंड वी आर रनिंग.
Second appeal number 21 of 2022. Heard the learned counsel appealing on behalf of the parties. The matter arises out of eviction suit under BBC Act. इसका full form लिखिए. Bihar Building and JBC Act. 2002. ये Jharkhand Building within bracket Lease, Rent and Eviction bracket Close Control Act 2000. Hereinafter referred to as JBC Act. The alleged tenant is the appellant before this court, and there are concurrent findings recorded by both the courts with regard to relationship of landlord and tenant, and also default in payment of rent. Consequently, through this appeal, the appellant is challenging the judgment and decree dated 26/2/2022, within bracket decree signed on 24/3/2022, passed by learned district and additional sessions at 1 Godda in civil appeal number 6 of 2018, whereby the appeal has been dismissed and the judgment and decree dated 21/12/2017, within bracket decree signed on 17/1/2018, bracket close, passed by learned subjudge first Godda entitled eviction suit number 1 of 2009, decreeing the suit has been appealed. At the outset, it has just been pointed out by the learned counsel appearing on behalf of the respondent landlord that by virtue of execution of the decree, the appellant has been dispossessed. At this, the learned counsel for the appellant does not dispute this position, but has submitted that merely because the appellant has been dispossessed, the same will not make the case infructuous, and substantial questions of law having been framed in this case are required to be answered. This case was admitted by order dated 6/2/2025, and at the submissions made by the learned counsel for the appellants and upon perusal of the records, the following two substantial questions of law were framed: A and B. Before proceeding to decide the substantial questions of law, it will be useful to give little factual background, the issues framed and the findings of the court concerned. The plaintiff filed title eviction suit in connection with the suit property whose identity is not in dispute. And he claimed that he has purchased the suit property by a registered deed of sale dated 9/3/2006 by the last owner, and came in possession of the sale deed of the property His further case was that the defendant was in need of the premises for his business, so he approached the plaintiff on eve of Durga Puja 2006 and offered for giving premises on rent, which was accepted by the plaintiff on 1/10/2006, and the rent was fixed at the rate of Rs 300 per month. The relationship continued, and the defendant paid the rent, but in the month of June 2008, the plaintiff asked the defendant to vacate the suit premises on account of personal necessity. It was also stated that the rent was enhanced, so the plaintiff, that should be sufficient. But the defendant, the plaintiff approached the defendant to vacate, but the defendant did not vacate and stopped payment of rent from August 2008 and evaded payment of rent on one pretext or the other. Consequently, a clear notice was sent to the defendant on 21/1/2009, and ultimately, when no response was received and the defendant did not vacate the suit premises, the suit for eviction was filed on default as well as personal necessity, and also for arrears of rent. The defendant appeared. The defendant number 2 whom?
Brother
Mumtaz.
Mumtaz and first defendant number 1 is Khurshid, defendant number 2 is Mumtaz.
Both are related
Both are brothers.
and both are tenants.
Both are brothers.
Defendant number 1 and 2, who are full brothers, appeared and filed a written statement objecting to the maintainability of the suit, stating that there was no valid cause of action and also on limitation. However, it was their specific case that they were in possession of the property since 1966-67, and it was wrong to say that the suit property was purchased by the plaintiff by virtue of a registered deed of sale by the last owner. It was asserted that the sale deed was forged and fabricated, and the entire incident during Durga Puja, as asserted by the plaintiff, was denied. The relationship of landlord and tenant was completely denied. It was also denied that the plaintiff never approached the defendant to vacate the suit premises. Rather, the defendants were in possession of the suit premises on their own right by virtue of an agreement of sale executed by Tarini Prasad Shah dated 15/12/2003, who was the mother of the vendor of the plaintiff, correct? तारिणी प्रसाद
No.
सा अच्छा
Son,
तारिणी प्रसाद सा का बेटा नहीं था ना वो?
Vasudev Shah. हाँ.
अच्छा ठीक anyway तारिणी प्रसाद शाह ये agreement dated 15/12/2003. It was also asserted that the defendant never paid rent to the plaintiff. It was denied in para 8. The defendant number 1 and 2 had filed two different written statements, but were on the same lines. The learned trial court framed the following issues for consideration. the oral and documentary evidences as recorded in paragraph 7 and 8 of the appellate court judgment were reduced. The agreement on the basis of which the plaintiff was claiming the property was marked as Exhibit 1.
No, it is exhibit D. हम लोग का तो sale deed.
Plaintiff,
Plaintiff will sell.
sale deed, dated 9/3/2006, was marked as Exhibit 1, along with other exhibits regarding tax receipts and rate receipts, and also mutation, and also order of mutation. And so far as the defendants are concerned, number of documentary evidences were exhibited, including the rental agreement dated 5/12/1977 within bracket Exhibit A, then rental agreement dated 10/12/1990 within bracket Exhibit B, affidavit of Tarini Prasad dated 8/4/99 Exhibit C, sale agreement dated 15/12/2003 within bracket Exhibit D, and electricity bills to show that they were in possession of the property since long. ये कब के हैं?
ये भी उसी late मतलब before 2003.
It was the certified copy of the written statement of Mosamat Santi Devi filed in the title suit was also filed. It was also a case of the. Did you say that your suit for specific performance was pending? Yes.
Yes.
It was also stated in the written statement of the defendant that the suit for
इनके documents में इनका नाम mention है. Electricity bill ये सब जो लगाए.
कोई बात नहीं, वो फाइंडिंग पे हम लोग जाएंगे. Suit for specific performance.
Mumtaz नाम भी mention.
Suit for specific performance of contract was also pending. The learned trial court considered the materials on record, both oral and documentary, and while deciding issue number 3 and 4, held that there was a relationship of landlord and tenant between the parties, and while deciding and other issues were also decided in favor of the plaintiff. The learned appellate court also recorded concurrent findings so far as the relationship of landlord and tenant and other issues are concerned. However, the specific case of the appellant before this court is that there was intricate issue of title, and each were claiming title over the property. Such an issue could not have been decided by the learned court under JBC Act, the same being a summary proceeding. The title is required to be decided through a properly constituted title suit. For that purpose, the learned counsel has relied upon the judgment passed by the Honorable Supreme Court, reported in bracket 2002 bracket close 1 SCC 90. कौन सा वाला?
Para 7 is the fact and 14 and 15 is the finding. 14, 15, 16 and 17.
As bracket 2002 bracket close 1 SCC 90 para 14, 15,
17.
16 and 17. plaint return करने वाले?
This is Patna, 1991 to TLJR 41.
इसका लिखिए ना. And also the judgment passed by Honorable Patna High Court, 1991 SSC Online Patna 140. Paragraph number 63 onwards, and has submitted that para 63 in particular.
63 में para 68 is the main paragraph in which it has been stated that the plaint ought to have been returned for
pa-
preparation of
Para 68 to submit that small causes quote are required to go into the title only incidentally, and in case of intricate question of title, the plaint is required to be returned for presentation to a court having jurisdiction to determine the title. Paragraph 63 and 68 of the FOC judgment is quoted as under. The learned counsel has also relied upon the judgment reported in bracket 2010 5 SCC 401 paragraph 12 and 16.
this is unregistered sale is an admissible piece of evidence.
To submit that even the unregistered sale deed, unregistered agreement of sale, that is exhibit D, is an admissible piece of evidence, and therefore the learned courts have wrongly relied upon the provisions of section 17 and 49 of the Registration Act, and they ought to have relied upon the agreement to hold that even the defendant had an appropriate claim of title over the property.
And my contention is that the prima facie the case of the plaintiff that they inducted me in 2006 is falsified.
The learned counsel has also submitted that the case of the plaintiff that they had inducted the defendant as tenant in the year 2006 was prima facie not established. With regard to the first substantial question of law, the learned counsel has submitted that the agreement of sale being an admissible piece of evidence, and the defendant was already put in possession by virtue of the agreement of sale, and therefore there was no obligation on the part of the defendant to pay rent to the plaintiff, and consequently the substantial question of law is to be answered in favor of the appellant defendant and against the respondent plaintiff. With regard to the second substantial question of law, the learned counsel for the appellant has submitted that in view of the aforesaid facts and circumstances, the suit under JBC Act was itself not maintainable, as both the parties were claiming title over the property. The plaint ought to have been returned, and the parties should have been relegated for filing a regular suit for declaration of title.
Leadership para 63 of that Patna High Court judgment that says that leadership has referred, para 63 has also been referred,
Yes.
that the learned court below did not address himself to the vital aspect of the matter at all. The vital aspect was just about that it has been mentioned that I was in continuous possession, and there is no finding to that aspect that I have been in continuous possession since now. So that vital aspect would have.
The learned counsel has also submitted that the vital aspect in the present case was that the defendant was in possession of the property since 66, 67, and this aspect has not at all been considered by the learned courts, and by virtue of this, the entire claim of the plaintiff that they had inducted the defendant as tenant in the year 2006 is falsified. The learned counsel appearing on behalf of the respondents, on the other hand, has opposed the prayer and has submitted that so far as the finding with regard to landlord-tenant relationship is concerned, there are concurrent findings based on appreciation of oral and documentary evidences on record, and no substantial question of law has been framed on that point. He has also submitted that there is no scope for entering into such dispute as to whether there is landlord-tenant relationship between the parties. Considering the contours of the question of law framed and are to be decided by this court, the learned counsel has further submitted that so far as the agreement of sale, which has been relied upon by the defendant, Exhibit D is of the year 2003, and the same is an unregistered document. He has submitted that the first substantial question of law relates to part performance of agreement of sale and the defendant having been put in possession. The same is essentially relatable to section 53 capital A of Transfer of Property Act. He submits that after 2001, all the agreement of sale on the basis of which a person can claim protection under part performance of contract under section 53 capital A are required to be compulsorily registrable. He has also referred to section 17 within bracket 1 capital A and has submitted that in the said subsection, which is corresponding to the amendment in 53 capital A of Transfer of Property Act and simultaneous amendment in section 17 of the Registration Act, there is a clear mandate that for the purposes of part performance of contract, unregistered agreement of sale cannot be looked into. He has submitted that unregistered agreement of sale can be looked into for any other purpose and in any other nature of litigation, maybe even in specific performance of contract. But so far as the claim on the basis of part performance of contract is concerned, the same is clearly inadmissible in evidence. And consequently, the claim of title of the plaintiff by virtue of part performance of contract in terms of the agreement, in terms of unregistered agreement of the year 2003, the same cannot be sustained in the eyes of law, and accordingly, the defendant did not even have any prima facie title with regard to the property involved in the present case. He has also submitted that merely because suit for specific performance of contract is pending, the same by itself will not give title to the plaintiff. For that purpose, he has relied upon section 54 of the Transfer of Property Act and has submitted that section 54 clearly indicates that by virtue of agreement, the property does not stand transferred. There you have it.
Apart from that, so far
Just the learned counsel has relied upon the judgment passed by Honorable Delhi High Court in WP Criminal.
Supreme Court of India, 2020.
As relied upon the judgment passed by the Honorable Supreme Court in reported in bracket 2023 bracket close 7 SCC 361 and has referred to paragraph 9 and 15 of the said judgment.
For my purpose, no.
9 से चलेगा सिर्फ पैरा 9 लिखिए. The learned counsel has also relied, which is quoted as under, the learned counsel has also relied upon the judgment passed by Honorable Punjab and Haryana High Court which is reported in 2011 CCC 3, which is reported in 2011 SCC Online Punjab and Haryana 5681, and has submitted that that it has been held as under इसको डाल दो, पैराग्राफ ही नहीं है इसमें, मार्क क्वेश्चन है लास्ट पेज में. The Learned Council has further submitted that so far as the second substantial question of law is concerned, it is not in dispute that the court could have gone into the prima facie title, prima facie title of landlord and tenant. For this, he has relied upon the judgment. He has also relied upon the judgment reported in bracket 2002 1 SSC 19, which has also been relied upon by the Learned Council for the appellant, and has submitted that the appellant did not have any prima facie title over the property, and the plaintiff was claiming the property by virtue of registered sale deed, which the appellant stated that the vendor was of unsound mind. This plea has been rejected by the Learned Court, and the registered sale deed has not been challenged by the appellant by any suit. He has referred to the section 58 of the Registration Act. 60 of the Registration Act to submit that a registered document is considered to be prima facie evidence of its execution in accordance with law. That's all.
One more thing I already submitted, that the scope of adjudication of title is foreign to suit under the.
The Learned Council has also submitted that the scope of adjudication of title with regard to the property is alien to the adjudication of landlord-tenant relationship in a suit for eviction by landlord.
The judgment, Rajendra Tiwari judgment for appeal.
Arguments concluded. अब हम क्या बोलेंगे? My stenographer may not be able to type it tonight. कल इसको 2:15 रखना for further dictation.
My friend has argued so well.
Oh yes,
I agree.
he always argues well. It's a pleasure listening to both of you.
Landlord-tenant relationship, it is very difficult to argue on that.
मेहनत तो किया बहुत, इसमें कोई डाउट ही नहीं. She argues with lot of clarity. Tomorrow at 2:15. कल 2:15 में तो कुछ नहीं है. क्या?
कुछ नहीं.
आपका कुछ नहीं. किसी और का तो कुछ हो ही सकता.
नहीं, एक्चुअली रेफरेंस के बारे में.
कल रेफरेंस
नहीं, 4 तारीख को है.
अच्छा नहीं कल नहीं. कल अगर टाइम बचेगा तो लिखाएंगे. एक कल बैच है, अगर ये खत्म हो जाता है तो लिखाएंगे, और नहीं तो मंडे को लिखाएंगे. ठीक है? मंडे नहीं, जब भी आएगा. और अगर हो सकता है कि जब भी आएगा तो जजमेंट लेकर ही आए, हो सकता है कोर्ट में नहीं भी लिखे. As the court time is over, the arguments are concluded. As the court time is over, post this case for further dictation tomorrow at 2:15. और ऑर्डर्स कुछ है आप लोग का? अच्छा एक जजमेंट बुक के जजमेंट प्रोनाउंस करना चाहिए.
For judgment for bail list item 1, second appeal 190.
Both the substantial questions of law are decided against the appellant. And in favor of the respondents, this appeal is dismissed.
order 17 serial में है. Notices, this is an admitted appeal, notices are issued, but due to the response number 1 was substituted by his legal heirs, but the notices to the legal heirs could not be issued.
आपका ऑर्डर्स में लगा हुआ है ना?
Orders में मुझे उसको हम within 2 weeks I will take this. That
अभी
is the
17 क्या 17 हम लोग सारे ऑर्डर्स कॉल करेंगे, आप लोग कहाँ जा रहे हैं?
हम सोचे
ऐसा नहीं,
ठीक है, चल रहा है।
रुकिए, जो नहीं आएंगे उनका पास ओवर करें.
ठीक.
जिनको अपना ये सब्स्टिट्यूशन और डिलेड और ये सब करवाना है, दे शुड वेट. हम सुबह सुबह जो है ना अपना 2 घंटा इस ऑर्डर्स में नहीं बर्बाद कर सकते.
Item 6, second appeal 691 of 2016.
अब बोलिए क्या हुआ?
इसमें हो जो हमारा ये अलाउ करके डिग्री को सेंड बैक किया गया था फॉर करेक्शन.
अच्छा, हो गया?
बट फ्लैग एल इज द लेटर ऑफ द एडिशनल डिस्ट्रिक्ट जज कि वहाँ पर जो मेमो ऑफ अपील है उसमें ही लिखा हुआ है 10,000 सूट वैल्यू और टाइटल सूट का वैल्यू है 1 लाख. तो वहाँ पर वो गड़बड़ी है, उसी के चलते डिग्री में
आप वहाँ पे
करेक्शन.
कोर्ट फीस कितना लिए थे?
ये तो देखे हम नहीं
और देख के बताएंगे.
आप देख के बताएंगे, देख के बताएंगे. तो हम इसको वेरीफाई कर लेते हैं उसके हिसाब से.
Verify.
जी, 2 वीक्स का टाइम कर दिया है.
The learned counsel for the appellant seeks adjournment. और ये भी सोच के आइएगा कि अगर वैल्यूएशन कम किए हैं
हाँ,
और अगर कोर्ट फीस कम दिए हैं तो उसका क्या उपाय है?
क्या उपाय है? जी जी.
कैसे होगा मिस्टर शर्मा? अपील में कुछ वैल्यूएशन में एक जीरो छूट गया और कोर्ट फीस भी कम दे दिए तो क्या होगा?
सूट में
लिखा हुआ है उसमें डिग्री में,
वही है ही, वही प्रॉब्लम है, वही है.
नहीं तो उसको तो किया जा सकता है. तो
कैसे होगा?
भेजना
भेजना होगा फॉर व्हाट?
करेक्शन.
फॉर करेक्शन ऑफ द
Memo
प्लेंट
में ही
ऑफ द मेमो ऑफ अपील.
वहाँ मेमो ऑफ अपील में गलती है.
सूट में
चिट्ठी
ठीक
है.
है.
हाँ, सूट में ठीक है.
सूट
1
में-
लाख
नहीं तो कोर्ट फीस भी तो कम दिए होंगे ना.
सूट में ठीक बोल.
सूट में ठीक है, अपील का
नहीं तो अपील में तो जो वही जो दिया हम सूट में वही देंगे.
क्या पता क्या दिए हैं.
वही कानून तो वही
कानून तो वही है, लेकिन एक सुनना छोड़ दिए है तो क्या ही बोलेंगे.
देंगे. तो सुनना बढ़ा देंगे, अपना दे लेंगे.
डिग्री में तो लिखा ही होगा.
नहीं, डिग्री में तो उतना ही लिखा है जितना अपील में लिखा है.
हाँ, तो वही उतना ही हमको पे करना होगा जो डिग्री में लिखा हुआ है.
अरे भाई 1 लाख का वैल्यूएशन है, अपील में छूट गया 1 जीरो.
यही करेगा तो जो उसमें ट्रायल कोर्ट का अपीलेट कोर्ट का दोनों का टिकट नाम करके that will be corrected by the appellate court.
And remaining
And
court
then-
fees
and
will be
then
paid
The appellant was there, has to be directed
to pay the
pay
balance
the
court
deficit
fees.
court fee.
ठीक है, समझ गए ना?
जी,
नहीं तो
तो
ये सेकंड
mistake
अपील
of-
आपका पेंडिंग रह जाएगा.
That is a clerical mistake, and that was the section 152 CPC.
and it will be rectified before the
By the appellate court.
appellate court.
आपको जो करना है करके आइए.
जी जी
हम आपको ज्यादा लंबा टाइम दे देते हैं.
जी.
पोस्ट ऑन 6th में और लंबा टाइम चाहिए.
कितना कितना बोला गया?
6 मई.
हाँ, ठीक है.
ठीक, चलो.
Publish.
Order item 7, second appeal 481 of 2016.
Substitution, IE number 3.
Whose substitution?
For appellant number 4.
वकालतनामा
Wakalatnama we have not filed one.
अपाई शेड्यूल देखिए. एसए नंबर 481 of 2016. Counsel for the appellant. Praise for time. To file वकालतनामा on behalf of proposed legal heirs and successors of
Appellant number 4.
appellant number 4. Post on 1st of May.
Item 8, second appeal 62 of 2017.
This is the admitted second appeal also. And notices were issued to the respondent number 1 to 30. Vacancy office note also.
क्या हो गया? आधा लोग मर गया.
नहीं, मरे नहीं है. Respondent number 1, 2 and
6
4.
has expired.
हाँ.
देखिए. और किसी के ऊपर फ्रेश सर्विस लेना है आपको.
Press service जाएगा. Respondent number 11, 12 and 13.
पार्टीशन सूट है. addressee could not be located. Respondent number 3 and 8.
3 and 8 also.
3 and 8 also. Respondent number 6 has expired. Correct? और respondent number 5 and 7 इनको भी at present and correct address जाएगा. Respondent number 11 to 13 ये भी out of
Answer.
station. लिखिए. Essay number 62 of 2017. Respondent number 1, 2, 4, 3, 5, 6, 7, 8 and 9. 9 कौन है?
9 है ऑफिस क्लर्क. ऑफिस क्लर्क का है उसमें.
कौन है 9? Deputy Commissioner. 9 and 10. As per report, as per office note, has been served either personally or through their close relation or through office clerk. Respondent number 9 has been served through office clerk, as respondent number 9 is the Deputy Commissioner. Considering the office note in connection with service of notice regarding ordinary process, the notice is accepted as validly served upon respondent number 1, 2, 4, 3, 5, 6, 7, 8, 9 and 10.
6 received.
Oh, sorry. 5.
Right.
It has been reported that respondent number 6 has expired. So far as registered cover is concerned, some of the addressees could not be located. But as per report of ordinary process, respondent number 3 and respondent number 8 have been served through their close relation. Five and 7 का क्या है? Not reciting. इतना contradictory कैसे? Ordinary process का इसका
ऑर्डिनरी प्रोसेस में तो
एकदम contradictory है. 6 का डेट नहीं बता रहा ordinary process.
एक में डेट बताया.
एक में डेट बता रहा है. इसका सर्विस ऑफ नोटिस में बहुत डाउट है.
फिर से स्टेप्स एक बार ले लेते हैं.
हाँ,
फिर से ले लेते हैं
ऐसे
फिर क्लियर हो जाएगा.
जिन लोगों को पर्सनली मिला है उनका बात छोड़ दीजिए, बाकी हम लोग नहीं मानते. फिर से लिखिए तो ऐसे नंबर 62 of 2017, respondent number 6 has been reported dead. Respondent number 1, 2 and 4 has been personally served. Respondent number 9 has been served through his clerk. Consequently, their services are accepted as valid. So far as other respondents are concerned, the counsel for the appellant prays for and is granted 15 days time to take fresh test for service of notice
इन पर
under ordinary process in their present and current address. He has also prayed for time to take steps in connection with respondent number 6 who has been reported dead. Post this case on the recusals we filed within 15 days तो हो गया. Post this case on 10th of June.
Item 9, second appeal 258 of 2019.
The office note says that all the respondent, the notices have been served upon all. Nobody has appeared, so it can be heard any day.
Yes, why not? Substantial question of law has been framed.
हाँ सर सब कुछ है.
अरे हम भी बनाए इसलिए हमको पता है. चलिए बताइए क्या करना है.
And notices have been served as per the office, so it is ready for it.
LCR has not been received.
So then it has to wait. Yes.
देखिए, as per office note, the notice to the respond number 1, 2 and 3 either has been received by themselves or by their close family members. Therefore, the notice upon respond number 1, 2 and 3 is accepted as valid. LCR आ गया? Counsel for the appellant has submitted that notice having been served, the LCR has already been received and therefore this case may be posted for final hearing. अगला डेट में करेंगे नहीं क्योंकि रेस्पोंडेंट को एक मौका और देंगे आपके पोस्ट दिस केस ऑन 15th April under the heading for final disposal. In the meantime, it will be open to the respondents to enter appearance. And if the respondents do not appear by 15th of April, then an appropriate date for final disposal will again be fixed.
Item 10, second bill
इसका
137 of
execution चल रहा है?
2020.
या तो plaintiff?
Execution नहीं चल रहा.
आप plaintiff हैं?
नहीं डिफेंडेंट है.
डिफेंडेंट ने कैसे नहीं एग्जीक्यूशन चल रहा होगा? स्पेसिफिक परफॉर्मेंस ऑफ कॉन्ट्रैक्ट में एग्जीक्यूशन नहीं चलेगा. मानने वाला बात नहीं है, पता कर लीजिए. आइए भी शायद पेंडिंग है ना? एग्जीक्यूशन में सर्व करेंगे नोटिस तो बता दीजिए.
ये तो
लिमिटेशन.
आइए नहीं.
अच्छा
ये नहीं है.
देख लीजिए एग्जीक्यूशन चल रहा है कि नहीं. हाँ बोलिए, आपका क्या है ये?
इसमें नोटिस इशू हुआ था रेस्पोंडेंट नंबर 5 देख कर लेंगे.
Essay number 137 of 2020. As per office note, respondent number 5 has been reported dead. Respondent number
1, 2, 3.
1, 2 and 3
Yes, Lordship, sir. We have already filed wakalatnama.
have already appeared by filing wakalatnama. Counsel for the respondent number 1, 2 and 3 is present. 4 number?
4 नंबर में मिस्टर संजय तिवारी स्टेट
State.
अपीयर करते
आप हैं?
1, 2, 3.
Respondent number 4 is the deputy commissioner. Who will be represented by the state council. However, किसी का नाम अपील कर रहा है?
मिस्टर संजय
किसी का नाम अपील कर रहा है?
Yes.
एडमिट हुआ था.
On the date of admission, the name of Sanjay Tiwari.
ठीक है, ठीक. At the request of the council for the appellant, post this case on. बताइए कब तक आप क्या फाइल कर देंगे? Substitution
3
करना है?
weeks lords.
23rd April.
Item 11, second bill 40 of 2022.
Yes. Are you the appellant?
Yes, please. The notices to respondent number 1 has been received by
Through
the
son, through
and
nephew.
through nephew. Respondent number 2 has received through nephew.
Son of respondent number 1.
Yes, ma'am.
Is there any? Is it a partition suit?
No, ma'am. The previous one is.
There is no conflict of interest amongst them. Respondent number 1 and
Respondent number 1 is the claims to be the descendant of the original buyer, and respondent 2 claims to be the purchaser of this particular property.
so they are in the same boat.
They are on the same.
देखिए, essay number 40 of 2022. As per office note, respondent number 1 and respondent number 2 have been served through their close relation. Accordingly, the notice upon respondent number 1 and 2 is accepted as valid. Respond number 3, 4 and 5 are to be represented by the State Council. Record आगे?
Yes, my listen, the last ticket has been recorded.
The records have already been received. In order to enable the private respondents to enter appearance, the matter is directed to be posted on 15th of April under the heading for final disposal. If they do not appear by that date, another date will be fixed for the disposal of this.
Item 12, second appeal 161 of 2022.
According to office report, Lord, the service report of respondent number 4 I have not been received.
Essay number 161 of 2022. Let this matter be posted on 16th of April, awaiting service.
Item 13, second appeal 173 of 2022.
Yes.
Lordship, response number 5 died.
Essay number 173 of 20. Respondent number 5 has been reported dead.
And respondent number 9 and respondent phone.
The learned partition सूट है क्या है?
Title.
Counsel for the appellant has submitted that बाकी का तो इतना ज़्यादा क्लोज रिलेशन है. The counsel for the appellant is directed to take fresh steps for service of notice upon respondent number 9 at his present and current address, for which requisites be filed within a period of 15 days from today. So far as other respondents are concerned, appropriate order with regard to service of notice upon them will be passed on the next date.
Ladies, I have received Okatma for the respondent number 1, 2, 3, 4, 6 and 7. 1, 2, 3, 4.
6 and 7. What's your good name?
Ram Kinkar.
Ram?
Kinkar.
Mr. Ram Kinkar, advocate,
Yes.
undertakes to file wakalatnama on behalf of respondent number 1, 2, 3, 4, 6 and 7.
Today I have.
1, 2, 3, 4, 6 and 7. Respondent number 8 has been served through the clerk. Respondent number 8 is a deputy commissioner. Must be the deputy commissioner. Respondent number 2, 6, 10 and 12 have been personally served. Respondent number 1, 3, 4 and 7 have been served through their brother. That is respondent number 2. Respondent number 11 has been served through mother, who is respondent number 10. Respondent number 13 has been served through respondent number 10, the sister-in-law. In view of the office note, the notice having been received by close relation, the service of notice upon the aforesaid respondents is accepted as valid. और respondent number 9 का आप कर देंगे? हो गया? अब कुछ बचा क्या? चेक कर लेंगे, कुछ बचेगा तो कर देंगे. रिकॉर्ड आ गया? रिकॉर्ड बताइए, रिकॉर्ड आ गया, आप लोग तैयारी में होते मैच करने के लिए. चलिए. Post on 11th of June. Present and correct address में 15 दिन में करके ना ऑर्डरली प्रोसेस में.
Item 14, second appeal 190 of 2022.
Yes.
Number 3 से
ये पार्टीशन सूट है क्या? टाइटल सूट है। आप कौन है?
हम रिस्पोंडेंट नंबर 3 से फिर
और बाकी लोग से क्यों नहीं? सब आपके भाई बंधु हैं,
हाँ भाई बंधु नहीं, इसलिए हमको एक ही वकालतनामा मिला है।
इसीलिए एक ही मिले।
अभी एक ही मिला है, इसलिए हम अंडरटेक नहीं करेंगे।
Yes, essay number 190 of 2022. Counsel for the petitioner and respond number 3 is present. Respond number 4 has received the notice personally. Therefore, the notice is accepted as valid. So far as other respondents, that is respond number 1, 2, 5 to 7 are concerned, they have been served through their brother, that is respond number 4. And accordingly, notice upon respond number 1 to 3, 5 to 7, 1 to 7 is accepted as valid. हो गया? 7 respondent है.
7 respondents.
Counsel for the respondent number
3
has submitted that he shall seek instructions, and if so approached, he shall file the wakalatnama on the behalf of other family members of respondent number 3. Records are it?
Okay.
क्या है ये? Substantial question of law बन गया?
That has been conveyed.
The records have already been received. Post this case on 15th of April, awaiting for final disposal, awaiting the appearance of other respondents. If the other respondents do not appear by 15th, another date will be fixed for final disposal of the case.
Item 15, CMP 1078 of 2022.
Yes.
Last question was substituted means legal heirs of Fuleshwari Devi were noticed.
Okay.
Upon the service report, we came across that Fuleshwari Devi has left. So notices were issued to 7 persons as they are at page number 4, paragraph number 4, my lord.
1 to 27 except 21 has been filed. OP number 22 was deleted.
Yes. One Fuleshwari.
21 was deleted.
My lord, the legal heirs of respondent number 8.
ये बहुत complicated है आपका delete इसको. 5 बज गया.
Next day.
इतना देर बैठ गए आपको अच्छा ही नहीं लगता है आपको. हाँ बताइए. छोड़िए ऐसा हमारे बोलने से नहीं. Limitation है आपको reply file करना है limitation का.
नहीं इसमें क्या हुआ ना सब्स्टिट्यूटेड लीगल एयर्स के ऊपर नोटिस किया
हाँ.
Substituted
तो
नहीं
वो
हुआ सर. Substituted नहीं हुआ.
अभी substitute नहीं हुआ proposed. हाँ.
तो उसको वो कहता है कि आउट ऑफ स्टेट वो लोग वहाँ शिफ्ट कर दें
Altogether 7 legal heirs are there, my lord.
हाँ.
और शिफ्टेड टू अनदर प्लेस
Out if my lord may come to
तो
pay.
सर्विस रिपोर्ट कहाँ है इसमें?
लगा हुआ flag में है. Flag है. I've just seen the records.
सर्विस रिपोर्ट तो हमारे ऑर्डरशिप में ही रहेगा. ये है लिमिटेशन. ऐसे नहीं होता ना, यहाँ पे लिखेंगे ना.
Exactly. Yeah.
अब हम लोग रिकॉर्ड पे खोजते
ऑफिस
हैं.
नोट में लिखना चाहिए
ऑफिस नोट में लिखना चाहिए ना. देखिए CMP है. CMP number 1078 of 2022. The matter has been placed without office note. Post on Tuesday. नहीं है आप बाहर जा रहे हैं. ट्यूसडे छुट्टी है तो वेडनेसडे थर्सडे किसी दिन भी लगा दीजिए. थर्सडे लगा दीजिए.
Thursday. Can it be on Wednesday, madam? Second, if possible. Second, I'll come.
वेडनेसडे कर दीजिए. सेकेंड हाफ फर्स्ट हाफ नहीं होगा. 4 ही बजे होता है.
4 बजे.
ये सब सब्स्टिट्यूशन और ये सब 4 बजे. चलिए.
Item 16, 2nd April 30 of 2023.
लास्ट है ना ये. 4 और हाँ बताइए.
Pursuant to last order, notices were issued upon the sole respondent on the ground that a compromise is being.
हाँ क्या हुआ?
I have received wakalat tomorrow. I will file wakalat.
ऐसे नंबर कॉम्प्रोमाइज हो रहा है?
Yeah, talk of compromise in some part payment.
तो आप लोग करिए ना भैया, क्या आप लोग किए हुए हैं? पार्ट पेमेंट हैज बीन मेड.
So,
अब जॉइंट कॉम्प्रोमाइज फाइल कर दीजिए.
substantial part of the total agreed amount has been paid.
कितना में सेटल होने वाला है?
I'm not sure of the total amount, but it is in excess of 3 crores. I think.
3 करोड़ दे दिए?
70 lakh.
76 lakh has been paid.
देखिए हियरिंग करेंगे ना तो आपका सेकंड अपील डिसमिस कर देंगे तो क्या होगा?
Therefore,
Therefore, how much time do you need?
the client has instructed he needs four months to complete the entire process. It has been agreed
मीडिएशन में भेज देते हैं. भेज दें?
that
बताइए वकालतनामा मिल गया?
हाँ मिल गया.
फाइल करिए. सेकंड अपील नंबर 30 of 2023. Counsel for the parties are present. The counsel for the responding Mr. Namul. Pran Pranay has submitted that he has received wakalatnama on behalf of the sole respondent. He has also confirmed that talks of compromise is going on between the parties. Let the wakalatnama be filed. The matter be posted on next Wednesday in the supplementary cause list to be taken up at 10:30. The parties to seek instructions as to whether they are ready to settle the matter through mediation. Correct? Mediation in Jharkhand.
they occur because both the parties
यहाँ पे जो mediation होगा आपका वहाँ कहीं नहीं होगा. Mediation in Jharkhand.
it has been agreed. It's just that the payment is
कोई बात नहीं.
large, therefore they are taking time to make sure that there is an agreement between the parties.
Supplementary list Wednesday को नहीं होगा तो Thursday को supplementary करेंगे. अभी और बाकी कितना आप लोग सोचिए आप लोग
Item
मतलब
17.
DFD कर करके बर्बाद कर दिए हैं पूरा litigation.
Item 17, second appeal 230 of 2020.
DFD और बताइए क्या
In
है?
this case, there are two appellants, two respondents. Respondent number 1 died. He was substituted by order dated 9/12/2024. But unfortunately, the legal heirs who have been incorporated subsequently after
देखिए second appeal number 230 of 2030, the learned counsel for the appellant placed for 15 days time to comply the order dated
only on legal
29/1 जो भी है जो उस ऑर्डर में उसको कंप्लाई करिए. लीगल ईयर्स को ही तो जाना था.
नहीं लीगल heirs छोड़िए दूसरा का ऑलरेडी सर्व हो चुका है, ऑलरेडी गया हुआ है नोटिस. लास्ट ऑफिस नोट देखा जाए.
Respondent number 2 को ordinary process से गया था. It is to mention that respondent number 1 has already died, substituted by order dated 9/12/24. But no requisite of notice upon respondent number 1A to 1F was filed.
बस 1A to 1A.
हाँ तो वही
2 पर सर्व
2 पर served है. We are not bothered about it. Respondent number 2 को भी notice हुआ था क्या?
जी.
देखिए second
It is
appeal
an
number
admitted
230 of 2023. Counsel for the appellant prays for and is granted 1 week time to take steps
Two
for
weeks.
2 weeks time to file requisites of service of notice upon respondent number 1A to 1F under ordinary process.
और थ्रू पुलिस स्टेशन पे सब छात्रा पुलिस स्टेशन एक ही जगह पे.
Under ordinary process. Post on 10th of June, Navalny Service Report.
Item 18, first appeal 301 of 2023.
Yes.
Contesting respondent number 1 has already appeared. 2 to 10 have been served by to their close relatives. For 11 to 14
देखिए FA number 3 and 1 of 2023. The learned counsel for the appellant has submitted that the contesting respondent number 1 has already appeared. So far as other respondents except respondent number 11 to 14, they have been served through their close family members, either themselves or through their close family members. He prays for time to take fresh steps for service of notice upon respondent number 11 to 14 at their correct and present address, for which requisite be filed under ordinary process within a period of 15 days, 1 month,
1 week.
within a period of 1 week from today. So far as other respondents are concerned, the appropriate order with regard to service of notice will be passed on the next date. Post on seventh of May.
Item 19 first April 99 of 2024.
हमारा लिमिटेशन कहीं काउंटर फाइल केस में हम रिज्वाइंडर फाइल करेंगे
कितना लिमिटेशन?
688 दिन कर लिए
भी क्या क्या प्रॉपर्टी?
नहीं पार्टीशन सूट से
FA number 99 of 24.
Probate case
Counsel
भी
for
चल
the
रहा है
counsel for the appellant prays
3 weeks
for 3 weeks time to file rejoinder to the counter affidavit filed in the limitation matter. Post on 7th of May.
Item 20.
अभी और कितना आपका orders है? For
For termination of delay of 19 days.
19 days. First appeal है?
Yes.
Bank first listing है? हाँ?
Not listing but
Notice नहीं हुआ?
notice.
लिस्टिंग हुआ था खाली डिफेक्टिव केस था ना,
Yes.
इसीलिए लिखिए आइए नंबर
3105.
3105 of 2025 in FA filing number 9865 of 2024. इसको नंबर नहीं हुआ, FA number 56 of 25.
56.
हाँ, of 25. Issue notice to the respondents. कितना delay है?
19 days.
In the limitation matter as well as in the main appeal, for which requisites under ordinary process be filed within a period of 1 week from today. Let the records be 15 days बोलिएगा तो 2 साल बाद place करना है ना आपने, तो करने वाला बात करिए. Let the records be called for from the concerned court.
1 week.
1. Let the records be called for from the concerned court. ठीक है, आपका सब काम एक ही दिन में कर देंगे. Pose this case on 7th of May.